Hey everyone, Harry here to talk about a salvo of big fat motions that Donald Trump now has filed in the Mar-a-Lago case. That we'll get into the substance, but many of them have already been decided against him. Others are completely far-fetched and would be non-starters. Except, and this is the second point to emphasize always, they're now in the hands of Judge Eileen Cannon and her ability to either go off the reservation in some partial or full-bodied way, or else use them to really delay the proceedings. That risk, I think, is very hard to overstate. So in some ways, they are served up, particularly for her. Let's start with the main one, immunity. It sound familiar? So it's the same argument that he's lost definitively in the D.C. Circuit, and that he is, we're now all on tenterhooks waiting to see what the Supreme Court will do. It's, anything he did while president, he's immune for, etc. It's even weaker here in many ways because there's this factual finesse, you could say, although it's not very subtle, that makes him want to try to ground the conduct he's been charged with in presidential acts, like saying, put those in the box over there and send those over here. That is the things he did in the very end of his administration, which you could make an argument are official acts, but that's very precisely not what he's charged with. And for this reason, he's charged with the unlawful retention of documents. This occurs after his presidency, and you would think it's a particular non-starter to try to use immunity here. But where there's canon, there's hope. And they've tried to sort of massage aspects of the Espionage Act. I don't think it's even worth going into the arcana of this to make it seem like it's all sort of anchored in acts he took in office. And it's very easy to see Cannon getting caught up in this and, having some kind of analysis that it all derives from there, et cetera. And is there immunity for those acts? A question that should have basically zero relevance. Now, in addition, in the big fat immunity motion, they include a few extra arguments. I think you'd call them kind of policy arguments. The history of our nation's traditions is that presidents are often charged with doing bad things. Of course, they've never been charged before with a crime. But a few kind of very soft arguments, you could say, that maybe they think, are bait for Cannon, or that she can glom onto, and if nothing else, use to sort of confuse matters, as she is sadly wont to do. Otherwise, they lead with the same really bizarre argument based on Marbury versus Madison, and the notion that a court can't challenge anything a president does because this is a big area of presidential discretion. Very much not what Marbury says, and that's totally clear in the D.C. Circuit opinion. So, there's a few things, as I say, they've kind of layered in. Presuppositions of our political history, that kind of stuff that seems to be designed for her. All right, second, another one that we haven't seen before, which is another big fat motion that says the charges need to be dismissed because they are void for vagueness. So if you're a defendant and a law there says that, you acted offensively, or and you're honestly in a position like, what does that mean? How do I defend it? That's a violation of due process to convict you based on that. But Trump tries to exploit that principle for several fairly straightforward arguments under his charges. So he's saying terms like unauthorized possession. What does that mean? relating to the national defense. Whatever could they be talking about? What entitled to receive? Huh? So fairly straightforward statutory language that he's saying is befuddling, and you really can't pin down. So it's literally void for vagueness, and therefore a violation of the due process clause to hold him for it. And to me, that's just the kind of thing that you could imagine Cannon taking pretty seriously. So we filed 70 pages of motions, some under seal yesterday. And then a real discredited old chestnut. It's that, but you've heard it, it's out there in the water in certain conservative circles. And that is that the whole regime under which Special Counsel Jack Smith was appointed is unconstitutional. This was actually the main argument launched and lost in the Morrison versus Olson case way back when it had to do with the appointment of an independent counsel in the Ken Starr model. It's one of the reasons, though, to shore that up against not constitutional infirmity, but just to bring the independent counsel more under DOJ control. We now have the special counsel regs within the DOJ, which have proven somewhat deficient in recent events. But anyway, the argument is the appointments clause of Article 2 gives a power, for many conservatives, a really core power, to choose whom to appoint, which of your officers, et cetera, and to have untrammeled ability to do that. Like you couldn't tell the president that he or she, for their chief of staff, has to appoint somebody from Arkansas or someone of a certain political stripe. That's really an appointment that the president gets to make. And the argument goes that Jack Smith is an official under the Constitution who must have that same kind of protection and procedure. He is, is subject to the appointments clause, meaning, and if he were, of course, his appointment would be unconstitutional. But the argument has been, long since rejected, and he exercises certain authority, but it's all under the regs, and the regs were quite designed for this, under the ultimate, even though, in these cases, Merrick Garland has been very hands-off, but it's under the ultimate control of an attorney general with some, though fettered in some way. Anyway, a whole argument that you can't imagine anyone seriously thinking they would win in a different court, saying any special counsel appointed under the regs, the whole regs violate the appointments clause, which basically has to do with the president's power to appoint the most senior people around her or him. So that's, another real thick one. We know that a couple more are coming, including selective prosecution. And in some ways, I buried the lead, as they said, because Trump has requested hearings on each of those. And that, in the hands of a somewhat dithering, possibly biased Judge Cannon, could each eat up, weeks or more. So you stack these 5 up together, and they are really a potential recipe for months of delay, even though I think all of them, certainly immunity, any judge would make quick work on. The void for vagueness doesn't seem to me to hunt. The appointments clause, and these are the main 3. They've all either basically been rejected or are really far-fetched, but can't see those very basic notions actually controlling the good Judge Cannon. So we're looking straight at, on the one hand, unloaded cannons, you could say, but it doesn't matter because we can really see the shape of things to come if she chooses to act as her immediate, not just immediate, ever since she's been on the case, kind of course of conduct has been, which is to take seriously things that are very few judges would, and then sometimes even adopt things that no other judge would. Now, of course, in any of those instances, she's looking at the possibility that the DOJ could take up an appeal and recuse her if it's far enough off the reservation. But for just a lot of delays and gumming it over, and the void for vagueness one being in some sense legally novel, if she's careful, I think she could both delay, reduce the risk of being recused, and potentially even figure out a way to give Trump a pass. So this is would be in another case hardly noteworthy, but here we can see the shape of the river, as it were, and it bends and in every which way, and then maybe arrives at a Judge Cannon manufactured dry hole. That's the risk anyway. So we'll be following now these different motions for I think a good time, because I think it's likely she's going to really give them a lot of room to air them, have hearings, and the like. That's the state of play in Mar-a-Lago. Talk to you later. Thanks for tuning in. If you enjoyed this video and other Talking Feds content, please take a second to like and subscribe. Talk to you later.